Hello, and welcome to this webinar on wills and estate planning. And welcome especially if you are one of an estimated 70% of Americans who do not have a will. Getting a will done is something most people would agree is a good thing to do, but still many people don't do it. Maybe that's because they don't understand why they need a will or what happens without one. And we're going to be talking about those things during this webinar. So this webinar is offered by my law firm, Fiffick Law Group, and it's in conjunction with Legal Shield. For those who are not already members of Legal Shield is a largest underwriter of legal service plans in the United States. Members of Legal Shield are able to pay a flat monthly fee, and they and their family members are able to get a basic will, financial power of attorney, and a health care directive for no additional charge, in addition to the other member benefits. If you would like more information about Legal Shield and its products, you can find them at www.legalshield.com. My name is Mike Fiffick, and I'm the managing partner for Fiffick Law Group. We are the provider law firm for Legal Shield members in Pennsylvania, and our offices are located just outside the city of Pittsburgh. And we've been a provider lawyer for Legal Shield members in Pennsylvania for 23 years. So let's talk a little bit about what we'll cover today. We're going to talk about what a will does, what happens without a will, and in particular, we're going to talk about 5 real life situations, and I would bet that one of these situations is your situation, and help you understand what happens in the situation when you do not have a will. We'll talk to you about tips for using the Legal Shield app in order to initiate a request to obtain a will. Legal Shield members have an app, and you can find that app in your app store, whether it's an Apple or an Android. It's free to download, and you can download it and take a look at it and see what it does. And then we'll also talk about the process of getting your will done from the time that you initiate the request with the provider law firm through its completion. So let's talk about wills. I think that they are often misunderstood and underappreciated. Why don't most people have a will done? I mean, 70% of Americans without a will is a relatively surprising or shocking figure. And I think there are a lot of reasons why people don't get them done. The number one is probably procrastination. Most people aren't expecting to die anytime soon. And so getting a will done is just not on the top of their list of things to do. Many of us have a lot of other pressing issues that are demanding of our time. So procrastination is a big thing. Some might feel that it's too expensive to get done. And I don't really have an estimate of the average cost for a family to get wills, powers of attorney, and healthcare directives done, but I'm sure that it is several $1,000s. But for Legal Shield members, for the flat monthly fee, and the most basic family plan is $25 a month, it is a tremendous discount on what it would otherwise cost somebody to have a very good will done for them and their family. A lot of folks don't really understand why they need a will. And I think the difficulty is that they don't understand it in the context of their real life situation. And I think if they understood what happens given their life situation, that they would have a greater sense of urgency to getting a will done, and it would solve that procrastination problem. So what does a will do? Most basically, it directs the distribution of handling of your assets. Now here I should say that your will doesn't control the disposition of all of your assets. It does control the disposition after your death of assets that are titled in your name. Now, some assets that you have will not be distributed in accordance with your will. For example, if you have a real estate that is titled jointly with a spouse or somebody else with a right of survivorship, the deed will dictate where the property goes after you pass away, not your will. The same holds true for a joint bank account or accounts that have a beneficiary form associated with them, such as an individual retirement account, a 401k plan, a pension plan. All of those things have a beneficiary form that dictates where those assets go after you pass away. But it's very, very important for those types of assets to work in conjunction with the provisions of your will. So they work in tandem or cooperatively. And it's especially important if there's a chance that any of your assets will end up with a person who is under age 18, a minor, or it would go to somebody who's younger and you would not want them to have that money at that early age. So it's very important to make sure that your will and beneficiary forms or jointly held accounts work in tandem with one another. Will allows you to appoint someone that you trust to manage your estate. And that person is typically called an executor or an executrix if it's female. Generally might refer to it as a personal representative. Your will also allows you to appoint somebody to care for your minor children. So to take care of them physically, to dictate where they might live if you are not around, and also to appoint somebody as a trustee to handle the money for the kids. And there might be two different people, one to take care of the children and one to manage their money. Those might be two different people. The will also allows you to place age restrictions on the access to money that you leave to beneficiaries, and in particular to minors. So you are not able to leave money to minors just generally. They cannot receive an inheritance from you if they are under age 18. If you don't designate somebody to take care of that money, a court proceeding will have to take place in order to appoint somebody as the guardian or trustee of that money. And we can talk a little bit more about that later. Finally, a will allows you to make gifts to non-family members. And in this day and age of the greater number of non-traditional relationships and reduced number of marriages that are happening, this is particularly important if you've got a partner, a longtime significant other, a stepchild, or a friend that you want to leave money to. Really, a will is the best way to get that done. So let's talk a little bit about what happens whenever you don't have a will. And the first thing that you should understand is that if you don't create a will for yourself, your state is going to have a will for you. It's called the law of intestate succession. That law is based upon a lot of assumptions about how somebody would want their assets to be distributed at the time of their death. But these assumptions were created a long time ago, and they were created within the context of older-fashioned relationships. And our society has really changed over the years. Our definition of the family unit has changed over the years. And the law of intestate succession has not kept up with a lot of those changes and the way we view family relationships in this time. So the law of intestate succession in your state is unlikely to represent what you would want to have done with your money after you pass away. You can't take that chance. So let's talk about some real life situations and what happens whenever you don't have a will. And the first of these involves blended families. And so blended families are more and more common these days. Sadly, 50% of all marriages end in divorce, and folks might have to get remarried. So you might have children from a prior marriage, children from a prior relationship, all under one household. So the law of intestate succession provides that your surviving spouse is going to split your estate 50-50 with children from your prior relationship. And that can be a pretty difficult situation to have. Let's say that if you pass away, your spouse is left with the same household, and very likely significantly the same expenses, but is going to have half of the household income to now support that household. If you don't leave a will to provide that all of your assets are made available to your surviving spouse, and they're splitting it with your children from a prior relationship, your spouse now has half again of the assets that would otherwise be available to them to support them. So it's a real significant financial impact on your surviving spouse to not prepare a will and provide for them whenever you pass away. This can really create some difficult situations. For example, if the house that you all live in is titled only in your name and you're the one to pass away first, now you have a situation where half of the value of that house is going to have to be split between your surviving spouse and your kids. If you don't have enough assets in your estate otherwise to satisfy that 1/2 interest in the house, then you're setting up a situation where the house may actually have to be sold in order to satisfy that intestate succession to your kids. It can be a very difficult situation. You also might have a situation where half of that money is going to go to somebody who will have access to it other than your surviving spouse to spend it on behalf of your children to that prior relationship. Maybe that person who has the primary access to that money is your ex-spouse or the parent of your child. And sometimes those just aren't good relationships, that you don't have a good relationship with that person, or your new spouse especially doesn't have a good relationship with that person. And that can really create some very, very difficult situations if your spouse needs some money to help take care of your kids from that prior marriage. Difficult situation. So another very common life situation is unmarried couples, right? Fewer people are getting married, or they're delaying the decision to get married for a much longer period of time. We have same-sex marriages or same-sex relationships. And now, especially with the planning for long-term care medical assistance, we are seeing an increase in the number of couples who were married for a long time to get divorced for purposes of financial planning in their golden years. So there are more unmarried couples now than there ever have been. And this can create a difficult situation if you don't have a will, because the law of intestate succession does not make any provision for people that aren't blood related to you, right? So your significant other, your longtime partner, or whatever, are going to get absolutely nothing in accordance to the law of intestate succession. And this is a situation that hit home, especially for me. You know, in my life, I had a friend, Paul, who was dating another gal for a long period of time, and they were getting ready to get married. But they had been together for a long time. And I'm sure that Paul would have wanted his fiancee to receive all of his assets, but he never took the time to get a will done, and he died suddenly from a heart attack. And as a result, his significant other didn't receive any part of his estate, and it all went to his mother, who was really elderly at the time. But we're going to talk about that situation as well. But this was just a really, really tough situation. It's especially tough if you and your significant other live in a house that is titled to you only. And you know that none of that house is going to go to your significant other. Most of the time, you would want your significant other to have the ability or the option to continue living in that residence. That might have been their home for 5, 10, 20, 30 years. It's the only residence that they really know. Especially if you've got children, you may set up a situation where your children have to kick your significant other out of the house. And if there's not a good relationship there, you can only imagine how difficult that situation can be. Stepchildren is another very common situation with blended families. The law of intestate succession makes no provision for stepchildren. So if you pass away without a will, your stepchildren are not going to be treated as your children, and they will not be entitled to any portion of your estate. I know a lot of folks who have stepchildren who view those stepchildren as their own children, and they might like them to be treated just as their own children. That's not uncommon. So if you don't have a will, you're not going to be a provision in there for your stepchildren. Single parents, this is a really important situation to have a will, Because if you've got children, especially if they're minors, you really need to have a will to set up who is going to take care of those kids, especially if the other parent is just not around or not involved, and who is going to handle their finances that you have left for them. This is just really one of those love letter situations where your will serves as a love letter to your kids, that you leave things organized for really the ones who are just most precious to you. So it's really important for single parents, whether you are the primary custodian of your children or not. It's very, very important for you to have a will to set these things together to make sure that things get organized for your kids and their finances are handled. Now, maybe you're single, no kids, never been married. You might think that you don't need a will. Well, even in this situation, it's really important for you to have a will, because without a will, who handles your estate? The law of intestate succession, the law is going to identify classes of people who might have the ability to administer your estate. But I can almost guarantee that if you don't have children and you don't have a spouse, there are going to be 2, 3, 4, 5 people who have equal say or equal chance of serving as the personal representative of your estate. And you don't get to choose who that person is. The one who steps up to the plate might not be the one that you would want, or they may fight over who handles your estate. It will certainly require everybody who has an equal chance of serving your estate to renounce their right to do that in favor of somebody. So that just creates a lot of confusion and delay in getting your estate administered. And that delay may be very important in preserving the assets that you have in your estate. You also, the law of intestate succession may direct your money in places that you don't want it to go. So maybe you've got a significant other that you would prefer that money to go to. But if you don't, the first place that it's going to go is to your parents. And this is particularly a problem if you have an elderly parent who is eligible for some type of a government benefit, especially long-term care medical assistance, that has a resource eligibility element to it, meaning that they are not eligible unless they have assets that are below a certain value. So if you leave them money, that may cause them to be no longer eligible for that government benefit that they rely on. They'll have to spend your assets down and then try to reapply. And they may not be in a situation where reapplying is something that is easy for them, especially if they're elderly or they've got some early on stage of dementia or other health problems that make going through that application process really difficult. So don't leave that situation for your parent to have to deal with. So let's talk a little bit and I'll give you some tips on how to use the Will app in order to initiate the process of getting your will done. So as I mentioned, Legal Shield has an app. You can find it at the App Store or wherever you get those for Android. I'm an iPhone user, so I'm most familiar with that. You can download that app. It's free. And if you're a Legal Shield member, you can use it to initiate a request to get your wills done. Now, you can also use a paper questionnaire, and that is a more involved process, but it gathers a lot of good information. And I know that your provider law firm probably would prefer that you use a paper questionnaire because they're going to need a lot of information in order to get things done. You can also go to your provider firm's website, and the vast majority of them probably have the questionnaire available for you to fill out and submit to them. So those are 3 ways that you can initiate the process. Now, if you use the app is really intended as a conversation starter, right? It kickstarts this thing, and that's just in the palm of your hand. So, if you have a procrastination issue, hey, just get the process started. The law firm will facilitate it and make it as easy as it can possibly be. If you use the app, you're going to see that it asks for this information: your name, your contact information, your date of birth, marital status. We would like you to identify your spouse. That's very important for us to know. And whether you're separated or whatever the situation is, we're going to need to know that because that will really dictate some choices in the estate plan that we suggest to you. Very important to know your children and identify their birth dates. We need to know if they're under the age of 18 or not, because that's going to dictate, again, some decisions that you're going to make. Whether you have a pre or a post-nuptial agreement, also something important for us to know. Not very many people have those, but if you do, very important for us to understand that so that we can incorporate that into whatever we put in the will. If you've got a beneficiary who has a mental or a physical disability, leaving money to them from your will might be inappropriate. And it might be inappropriate if you've got a beneficiary who, again, is eligible for a government benefit that has a resource eligibility element to it. And we're not going to want to have money go directly to them because it'll render them ineligible for that benefit for some period of time. And we can put this money into a trust that can be used for their benefit, but will not render them ineligible for the government benefit. So they can keep the government benefit and also enjoy some benefits from the money that you leave from them, but there's some special planning that we have to do for that. If you are a green card or a non-U.S. citizen, that we would need to know that as well. There's some special planning that we have to do for folks in that category as well. It'll ask you to make some decisions about who the executor, that personal representative of your estate is, a guardian who would be physically taking care of your children, and a trustee who's going to manage the money for minors or to hold that money until people reach an age where you're okay with them receiving full access to the money that you left to them. Even if you haven't identified specifically who these people might be at the time that you initiate your request, go ahead and initiate the request anyway. You can always make these decisions later. Now, we're also going to need to know some information about your assets and like major debts, like a mortgage debt or some other type of a line of credit. It's going to be important for us to know the types of assets that you have and for us to identify what passes by virtue of your will and what passes by virtue of a contract or a deed or a beneficiary form. We'll want to work with you to make sure that those things work together and in partnership, as I had mentioned previously. If you have property in a different state, some folks have a family property that is in a different state left for them, or a camp, or maybe they've got a vacation home or something. We might need to know a little bit about that as well. And specific bequests, special things that you want to go to people in particular. Maybe it's a cash gift to somebody as a recognition of their friendship for a long time, or maybe it's a personal family heirloom. Sometimes folks want to leave guns or family jewelry, things of that nature. We might need to know some information about that too to help you plan for that. So again, the Legal Shield app is really the beginning of the process. It's a sort of a very short form digital questionnaire. We'll probably need some additional information from you in order to have all of the information that we need in order to complete your will. So what's the process look like once you initiate your request? So you've submitted the information to us via either the app or completing a will questionnaire or going online to your provider firm's website and initiating the request. When it comes into our office, we open a digital file. We call that an intake. And then we contact you to get any additional information or to clarify things that you have provided to us thus far. So that contact might be from a paraprofessional or a paralegal or an administrative assistant, could also be from one of our attorneys, but we'll be gathering some additional information and asking some additional questions of you to complete all of the information that we need in order to assist you in preparing a will, power of attorney, and advance directive that is appropriate for you. Our attorneys will review that information and consult with you as needed in order to make sure that we answer all the questions that you have about your estate plan and that we fully understand what your goals are so that we can put something together for you. We'll prepare a draft and we'll send that out to you within 5 business days. And once you approve it, we will send you the final with instructions on how to sign those documents. And typically in Pennsylvania, they should be notarized. I know all of our documents have notarization provisions in them so that they become a self-proving will, which just makes it easier for your loved ones to file that after you've passed away to begin the estate administration process. The package that we typically offer to Legal Shield members includes that last will and testament. It also includes a durable power of attorney. So there are 2 different types of powers of attorney, one for dollars and one for doctors, as they say. The durable power of attorney is for dollars. This is your way of designating somebody who can handle your financial affairs in the event that you are unavailable or unable to handle your own financial affairs. So for a married couple, this is typically your spouse or a child. And for an unmarried person, this would be your significant other or a close friend or a family member who can step in and handle your financial affairs in the event that you can't. This is a really, really important document for everybody to have because it's just so common for us to be incapacitated for some temporary period of time or maybe a long time towards the end stages if we have dementia or some other cognitive incapacity, and we just can't handle our financial affairs as easily as we could have. Very, very important document to have. And this is particularly important, again, at this time when there is more focus on planning for long-term care, the financial burdens of long-term care. You want somebody to have the ability to make changes to your assets, retitling your assets, changing beneficiary forms, things of that nature, that will be able to preserve your assets in the event that you have to go into a skilled nursing facility or you need long-term care. There's a lot of planning opportunities there that can preserve your estate for your surviving spouse or your loved ones. Then we also have a power of attorney for doctors, and that's called a medical power of attorney or an advance directive for healthcare. The document that we prepare for folks has 2 parts. The first part is a medical power of attorney, where you designate somebody to make medical decisions for you when you are temporarily unable to make or communicate decisions for yourself. So this is just a temporary situation where you're not awake, you can't communicate, and somebody can authorize medical treatment for you. Part 2 of the document is what many refer to as a living will. And this is a way for you to designate the types of medical treatment that you would or you would not want in the event that you are in an end of life situation. So you have an end stage medical condition and you are unable to make or communicate decisions for yourself at that time. So you can make those decisions by filling this document out to say, I do not, or I do want this type of medical treatment, or you can designate somebody to make those decisions for you while you have provided then some guidance on the types of treatment that you would or you would not want in that situation. So there might be some special situations out there that will require a more in-depth conversation about estate planning. Non-U.S. citizens, they're going to require some special planning. Generally, those folks do not have the benefit of the exemption for federal estate tax. And so we might want to do some special planning for those folks. Again, we've talked repeatedly about beneficiaries that have special needs. This is definitely something that would require some extra attention and some extra planning and drafting in your document to make sure that those folks aren't rendered ineligible for their benefits as a result of what you have left them in your will, or especially this is where a will and a beneficiary designation can work in conjunction. So if you have a 401k plan or an IRA or life insurance or some other type of asset that would be distributed not in accordance with your will, you would want that money to be paid into what is called a special needs trust that can be in your will and be administered according to the terms of that trust. So that's how a will and a beneficiary form type asset would work in conjunction with one another, that the beneficiary form would point that money back to a trust that appears in your will, and that trust comes into life after you've passed away to receive assets coming from whatever source to be administered in accordance with the terms of that trust. If you have a high value estate, I would say more than or approaching $5 million, then that's going to require some special planning as well, because the federal estate tax exemption, federal estate tax begins at 45%, so it's a very high percentage. If you are approaching an estate that could be subject to federal estate tax, then we will want to do some special tax planning for you in order to reduce the imposition of federal estate tax. Revocable living trusts. So in some states, revocable living trusts are the primary way of doing estate planning because the probate costs in other states are very high. In Pennsylvania, they're less prevalent because going through the probate process is not as expensive as it is in some other states. But some folks like to have a living trust, revocable living trusts prepared. And there are a wide variety of trusts that are used for different purposes for estate planning. Perhaps it's a life insurance trust or some type of a trust to benefit children that you can put gifts in on an annual basis. Perhaps you have a desire to give money to a charity, and we would create a charitable trust for you. So those types of trusts are going to require some special planning, and we can assist folks with those types of things. And Legal Shield members are entitled to a preferred member discount on the fees that they would have to pay otherwise in order to have those documents prepared. So that really covers the very basics of why you need a will and how to get it done, especially if you're a Legal Shield member. Legal Shield makes it very easy to get your will done and takes a lot of that friction, the procrastination, the expense. It takes all of that out of the way, and it really makes it so much easier for you to get your will, your power of attorney, and your healthcare directive done. So I have to give you the legal disclaimer that this presentation contains general information only, and it's not really intended as specific advice for anyone viewing this webinar. So if you need specific advice, and I would really highly encourage you to get specific advice for your estate planning needs, please contact your provider law firm or contact my law firm, Fiffick Law Group. If you're a Legal Shield member, all you have to do is pick up the phone and give us a call. It doesn't cost you anything extra. And you can talk to one of our attorneys and get specific advice for your estate plan and a specific will that fits your particular life situation. So thanks again for tuning in, and we hope to hear from you soon.